Hello dear students, let us today talk about article number 12 of Indian Constitution. What is article number 12 and how article number 12 defines a state? See, when we talk about article number 12 of Indian Constitution, article 12 of Indian Constitution, it is this article which defines what is a state. Okay? Now, so it defines what is a state. Now, very important, we must know in political science, when we say the term state, state has two different meanings. One, it is the state of Maharashtra, Punjab, such type of a state. That means a smaller territory within a country, right? This is one type of a state. Another type of a state is the authority. Authority is also a state. Okay? Now, article number 12 of Indian Constitution talks about this state. When article number 12 specifies a state or mentions a state, it means it is talking about authority. Similarly, we have article number 36 of Indian Constitution. Even this, when it mentions a state, it is talking about authority. Authority in what sense? We will talk later. Whereas, when you read part number 6 of Indian Constitution, part number 6 of Indian Constitution talks about this state, that is the territory, right? The smaller unit within a country. So, we will be talking about article number 12, that means we will be talking about this state. Okay? Now, another very important thing is, when we talk about a state, we must know that what is a state? Yeah, from where did the term state derive? So, this term state has derived from the Latin term called polis. Okay? And this polis means government or something which is related to governance. Okay? So, this state means government or something which is related to governance, right? Governance of your territory. So, when we say about this authority, right? This authority is what a state? So, this authority is what? It is government or something which is related to governance. Right? Now, article number 12 of Indian Constitution, to be very specific, it specifies what is this particular government or governance. So, it mentions, article number 12 of Indian Constitution mentions that at union level, we have union executive, right, which is nothing but the Modi government, and union legislature, means parliament. Right? Parliament. So, union executive is a government, we all know. Union legislature, by making laws, by making the laws, they are actually engaged in the activity of governance, right? They make law by which your country is regulated, by which the people in the country are regulated. So, even the union legislature is a state because it is engaged in the activity of governance. Then, at a state level, this is state level. Here we are talking about levels. Okay? At a state level, we have state executive like Shinde government, right? Like Bhagwant Mann government in the state. That government is what? It is the state. Then you have state legislature. So, because even state legislature, by drafting law, they what do? They regulate the territory of the state or the people in the state. So, even this is engaged in the activity of governance, hence it is what? It is a state. Then at local level, if we look at the local level, we have panchayat, right? Panchayat. Now, panchayat is engaged in the activity of governance. At village level, they do governance. Then we have municipalities. See? So, even this is engaged in the activity of governance in the local urban area. Okay? Then, after these three levels, we have another important thing mentioned in article number 12 of Indian Constitution, and that is authority within, yeah, you can say authority under the government. Right? So, these two are the government. Any authority which is under this government is also the state, right? For example, we have public sector units, PSUs, like LIC, right? Like SBI, These are the public sector units which are under the control of government. Government exercise control, government holds the share, right? Government has its control, government provides finance. So by these means they are also state, because they are under the government, because they are under the state, they are also termed as a state. Hence, if you fight against LIC or if you are fighting any case against SBI, you can say that you are fighting against the state, right? And then article number 12 of Indian Constitution mentions authority within the territory of India, within the territory of India. Now, this is again very important to notice, within the territory. These are the authority which are not within the government, which are not the legislature or the executives, and also they are not under the executive, but still they are considered to be state, right? So which are these type of authority? It is judiciary, right? It is UPSC, the independent body. It is the election commission, the independent body. These are the bodies which are not under the government, but still they are state. So if you fight against UPSC, you can say that you are fighting against the state, right? Now when we talk about judiciary, I have marked here a star mark. The reason is it has some very specific or you can say something very special to notice. When we talk about judiciary, right? Judiciary has two important roles. One is adjudicating role, which is nothing but the judicial role. Okay? This is judicial role. And the other role is administrative role. Right? Now, what is this judicial role and what is administrative role? When judiciary deals over any case, at that time we say that they are performing the judicial role. But when judiciary makes any appointment, like for example you might be knowing Supreme Court, High Court, they make the appointment of their staff. It is not any other body which makes the appointment for them, they make the appointment of the staff for Supreme Court or High Court. That is not the case. Supreme Court and High Court, it also performs the administrative role and it appoints its own staff, like the staff member in the court as well as the Mali or the drivers of the judges. They are also appointed by whom? So they are recruited by the Supreme Court itself. Okay? So performing such role is what is the administrative role of the judiciary. Now, while performing judicial role, at this time judiciary is not a state, it is not a state, but while performing administrative role, we consider it to be a state. Hence, if we find any dispute or any anything wrong in the appointment procedure, one can approach against this administrative role of Supreme Court in the judiciary, that is before the Supreme Court itself. So why we can go? Because it is a state and you can fight against the state. So this is the administrative role, and while performing administrative role, it is the state. Okay? But while performing the judicial role, it is not a state. Now the thing is, why do we not consider it as a state while performing the judicial role? While the Supreme Court or High Court, it performs the judicial role, at that time why judiciary is not considered as a state? This is in order to ensure that the principle of natural justice survives. Natural justice. Okay? Why? Because the principle of natural justice simply says party in the case cannot be the judge to the case, right? For example, if Supreme Court, if you consider the judiciary while performing judicial role as a state, take an example, if you have a fight against the union government is also a state. So you versus union government, this is the case, you two are the party in the case, union government and you. And if we consider the Supreme Court or High Court as a state, then what happens? Union government is a state, Supreme Court is a state, then this will lead to the violation of principle of natural justice. And that is the reason it is said that going with the principle of natural justice, judiciary will not be considered as a state while performing the judicial role. But at the time of administrative role, it is a state. Okay? Now, the next very important thing is, there is a many occasion when we see that instead of mentioning these bodies which are specifically mentioned in article number 12, sometimes the examiners, they have the tendency of quoting the name of some of the institution and asking whether it is a state or not. Like for example, CBSE, whether it is a state or not. NCERT, whether this one is a state or not. BCCI, whether this one is a state or not. Now, how to identify whether any body is a state or not? For this, we need to see whether the two conditions are fulfilled or not. If these two conditions are fulfilled, then it is a state. The very first condition, the body having direct jurisdiction over the people. Any body having direct jurisdiction, I mentioned direct jurisdiction, ठीक है, over the people, yeah, public, right? First thing. And second condition is whether the body is controlled by the government or financed by the government, right? Controlled or financed by government. If both of these two conditions are fulfilled, then such body, any of such body is a state, ठीक है, वो state है. Now you just need to see whether CBSE, BCCI या NCERT के case में this two conditions are being satisfied or not. For example, let us talk about BCCI. First condition, BCCI, does it has a direct jurisdiction over the public? I mean, does BCCI directly control the emotions or directly deals with the public? The answer is yes, right? By conducting a cricket match, they are in direct relation with the public. By collecting the the ticket charge or ticket fee, they are into direct relation with the public, right? So BCCI actually fulfills the first condition. It is in direct relation or it has a direct jurisdiction with the public. Okay? Now, what about second condition? Is BCCI controlled by the government or is BCCI financed by the government? The answer is no. Government has no control over BCCI. It is completely a private independent body and it is also not financed by the government in any way, right? So the second condition is not fulfilled. Because both of these two conditions are not fulfilled, it is not a state. It is not a state, right? Now let us talk about CBSE. Now, is the first condition fulfilled? Does it has a direct jurisdiction over the public? Yes. CBSE has a direct relation with the students. CBSE conducts the exam, examines the students and accordingly give them or award them the certificate by which they have the future course of development, right? So by doing this, they are in direct relation with the students, right? They provide the curriculum and accordingly they ask the student to prepare their course and then they examine the students, award them the certificate. So what is this entire process? In this entire process, Supreme Court has a direct relation with the public, right? So it has direct relation with these students. So hence we say that the first condition is fulfilled. Now the second condition is Supreme Court is CBSE controlled by the government or is it is financed by the government? The answer is yes, right? So because both of these two conditions are fulfilled, CBSE is a state. What about NCERT? Is this one is a state? We know the first condition is to have direct jurisdiction over the public. Now, does NCERT directly deals with the public? That means, does it directly deals with the student? The answer is no. Always remember, NCERT has no direct relation with the students, has no direct jurisdiction over the students. It is the, you can say, as the mechanism or it is the organ of the CBSE working behind the curtain for the CBSE, right? For example, CBSE has to deal with the students, CBSE has to examine the students. So it allocates the tasks to an NCERT to design the subject or to design the syllabus based on which they will be examining the students. So behind the curtain, it is this particular research organ which designs the syllabus. They prepare the the book, they provide it to CBSE, and based on this particular book, CBSE actually examines the students. So always remember, NCERT has no direct relation with the student, and that is the reason if you find any fault in NCERT book, you do not directly approach the NCERT, right? In fact, we never approach NCERT, we approach CBSE. We file complaint with CBSE, we demand the changes to CBSE, and it is CBSE that deals with the NCERT, and then they decide whether what type of changes is required, right? So remember, NCERT has no direct jurisdiction over the public, but yes, NCERT is controlled by the government or it is financed by the government. But here again you can see both of these two conditions are not fulfilled, hence even this one is not a state. This is not a state. Okay? So for any body to be a state, what is the essential condition? The condition is very simple. Both of these two conditions, that means first one having direct jurisdiction over the public, and the second one to be financed or controlled by the government, both of these two conditions need to be fulfilled. Okay? So I hope with this much of information you understood what is article number 12. We did it in a very holistic manner, and if you have any query you can approach me. I will definitely try to sort out your answer. Thank you. Till then, goodbye.